Picture this. It's just a regular Saturday morning commute, maybe like yours, the usual train sounds, people heading out, and then, bang, tragedy. A man falls, his life ends, and a family's world just collapses. But what happened next wasn't just personal heartbreak. It turned into this really intense legal fight, a fight that, as one judge put it, revealed some serious shadows on the tracks. Not literal shadows, but shadows in the legal system itself. Welcome to the deep dive. Today we're getting right into a specific, really significant Australian case, Commissioner for Railways v. Small. We've gone through the judgments, the documents, and we're going to walk you through this incredible story.
That's the plan. We're going to unpack all the drama, look at who was involved, the family, the railway, the lawyers, the judges.
Yeah.
We'll follow the legal steps, see who represented whom at each stage, and pinpoint where things, well, according to the appeal court, went seriously off the rails.
Okay, let's jump in. It all starts early morning, Saturday, September 5th, 1936. Around 5:30 a.m., R.W. Small is on an electric train in New South Wales. A normal trip, you'd think, but then he falls from the train. Fatal injuries. It's just, well, it shows how fast things can change, doesn't it?
It really does. And that loss, that tragedy, it immediately kicks off the legal process. A lawsuit gets filed. It's under the Compensation to Relatives Act, brought for Mrs. Small, his widow, and their kids.
Right. That act is specifically for this kind of situation, isn't it?
Exactly. It lets dependents claim compensation if someone's death was caused by negligence, covering the financial support they've lost. So for Mrs. Small, this was, well, obviously driven by grief, but also a desperate need to secure her family's future.
So what was the core claim? What negligence were they alleging against the Commissioner for Railways?
Initially, they put forward three things. First, that the train itself was driven negligently. Second, that the commissioner hadn't provided, proper safeguards near the train doorways.
Okay.
And third, they initially claimed something was wrong with the maintenance of the permanent way, the actual tracks.
3 different angles. Did all 3 make it to the trial?
No, actually. Before the trial even started, the plaintiff's legal team dropped that third one, the track maintenance claim. So the case went ahead, focused just on the first 2, negligent driving and the lack of safeguards.
Got it. And who is handling the case for Mrs. Small at this point?
Our sources show her solicitor, the lawyer managing the case directly, right from the start through the trial and the appeal, was a Mr. Arthur C. Kennedy.
Okay, Arthur C. Kennedy, the plaintiff. So we have the widow and children, represented by Kennedy, going up against this big government railway body on those 2 negligence points. Let's flesh out the key players, the sort of dramatis personae here.
Absolutely. So on the plaintiff's side, you've got Mrs. Small, the central figure, fighting for compensation. And her children, unnamed in the reports, but their future is riding on this.
And their solicitor, Arthur C. Kennedy, you mentioned his conduct becomes important later.
Very important. His actions, especially around the trial, end up being heavily scrutinized on appeal. And interestingly, his brother, C.S. Kennedy, also gets drawn into the controversies surrounding alleged witness interference.
Right. And the barristers, the ones actually arguing in court.
The sources don't name who argued for Mrs. Small at the initial trial. But for the appeal, which was clearly high stakes, she had top-tier representation. Evett K.C. and C.E. Martin, King's Counsel.
Okay, and facing them, the defendant.
That's the Commissioner for Railways, represented by their internal legal team. The solicitor handling it was Mr. Fred W. Bretnall, who held the title Solicitor for Transport.
And like the plaintiff, their barristers aren't named for the first trial.
Correct. But again, for the appeal, they brought in the big guns, Bradley, K.C., and Kinsella. So you see King's Counsel on both sides for the appeal. It really tells you how serious this had become.
And witnesses are always crucial. Any specific ones who became central to the controversies?
Definitely. The testimony itself was vital, of course. But it was the events surrounding 2 witnesses that became huge issues on appeal, a Mrs. Violet Mary Bradshaw and a Mr. Smith. Their alleged interactions with the plaintiff's side outside the courtroom were really put under the microscope later. And a Constable Cunningham was apparently present for one of these interactions.
And finally, the judiciary. Who presided?
Right. There was the initial trial judge, who wasn't named. His decisions on evidence and how the trial ran were, well, let's just say they were closely examined later. Then for the appeal, the bench hearing the case in the Supreme Court of New South Wales was Chief Justice Jordan, Justice Davidson, and Justice Owen.
Okay, so the players are set. Let's move to the first act. The initial trial. It starts Wednesday, April 27th, 1938.
That's right. Mrs. Small's case, presented via her solicitor, Arthur C. Kennedy, argued those 2 points. negligent driving, and lack of safeguards. The commissioner, represented by Fred W. Bretnall, denied liability. Evidence was presented, arguments were made by the barristers, again, unnamed for this stage. Then the jury went out.
And the verdict?
They came back in favor of the plaintiff, Mrs. Small.
A win for her.
A win. They awarded damages of 1,724 rounds, which, as you said, was a pretty substantial sum back in 1938, potentially life-changing relief for the family.
So on the face of it, justice served. But you mentioned earlier Chief Justice Jordan later described that finding, especially on negligent driving, as somewhat surprising.
Exactly. That comment is key. It's like a little flag popping up, suggesting that maybe the way that verdict was reached wasn't straightforward, that there were issues simmering beneath the surface of that trial.
And those issues definitely boiled over. Because that initial win for Mrs. Small was soon completely overshadowed by these really serious problems with how the trial was conducted. These problems became the entire basis for the commissioner's appeal.
Yeah, the first huge issue, the one Chief Justice Jordan really slammed, involved a subpoena. Specifically, a subpoena duces tecum. That means bring documents served by the plaintiff's solicitor, Arthur Kennedy, on the commissioner.
Okay, subpoenas are standard legal tools. What went wrong here?
Several things, apparently. First, the timing. It was served really late on Friday, April 22nd. The following Monday was a public holiday. So the commissioner basically only had Saturday and Tuesday to find and produce what turned out to be a huge volume of documents before the trial started first thing Wednesday morning. It put them under immense pressure.
That sounds like sharp practice, maybe.
Well, the court certainly thought the timing was an issue. But the bigger problem was the subpoena itself, its form and breadth. It used this really sweeping, vague language, something like demanding all documents relating to or in any wise concerning the matters in question.
That sounds incredibly broad, like asking for everything but the kitchen sink.
Exactly.
Yeah.
Chief Justice Jordan called that specific wording quite improper and actually ordered that no further subpoenas should be allowed to be issued, which include these words. So this case literally changed subpoena practice because of how bad this one was.
Wow.
And beyond the general wording, it demanded massive categories of stuff, like all documents about safety doors anywhere else, all documents about other falls from trains, all complaints ever made about train control. Jordan C.J. called these demands quite improper, and the whole act of issuing it like this, a serious abuse of the process of the court.
Why abuse? What's the reasoning?
Because, as the Chief Justice explained, a subpoena is for getting specific evidence needed for trial. It's not a discovery tool, not for fishing expeditions to see what you might find, especially not against a party like the commissioner who'd already gone through the formal discovery process.
Okay, so the subpoena itself was flawed. How is it actually used in court?
This is where it got, according to the judgment, particularly bad. Instead of the plaintiff's barrister giving a normal opening speech outlining their case, they immediately called a railway officer to the witness box. Not to give evidence about the accident, but to be cross-examined about the subpoena and the documents. Right there in front of the jury, first thing. Jordan C.J. called this regrettable.
Wait, so the jury's first impression is the railway being grilled about documents they supposedly haven't produced properly?
That's exactly the impression that Chief Justice found it created. He said it produced an erroneous impression that the commissioner was improperly hiding things. This likely gave the jury a lasting impression of wrongdoing from the very start, prejudicing them against the defendant before they even heard the facts of Mr. Small's fall.
So it wasn't just a technical issue with the subpoena form. Its use was a deliberate tactic, it seems, to prejudice the jury.
That's certainly the implication you take from the Chief Justice's detailed criticism. And this abuse then directly led to the next major problem, really prejudicial evidence getting admitted. Because the plaintiff's counsel got access to all these documents produced under the problematic subpoena.
Right.
They then managed to get files admitted into evidence concerning other, totally unrelated falls from trains, despite objections from the defendant's lawyers.
Other accidents. How is that relevant to Mr. Small's specific fall?
Well, the argument is usually that it shows a known danger or the feasibility of precautions. But here, the Chief Justice found it went way too far and was highly prejudicial. He specifically highlighted one file about a Mr. Skinner. This entire file was admitted in toto.
Okay.
And right at the front of this Skinner file, it mentioned that 2,000 pounds had been claimed in that case and that the railway had actually paid 1,000 pounds into court.
So the jury in Mrs. Small's case heard that the railway paid out 1,000 pounds in another accident case. That seems massively prejudicial.
It does, doesn't it? It has nothing to do with whether the railway was negligent in this case. Chief Justice Jordan described admitting the Skinner file with the payment details as matter more improper to be admitted or more likely to cause serious prejudice to the defendant. It could easily influence the jury on liability or how much money to award Mrs. Small based on an entirely separate incident.
And did the plaintiff's lawyers make use of this material?
Oh, absolutely. The judgment says plaintiff's counsel made great use of all these other accident files in his closing argument. He apparently criticized the defendant for trying to keep them out, and then described other accidents vividly using names, talking about horrific injuries, people maimed for life, some dying, clearly designed to stir up emotions and prejudice the jury.
Wow. So, improper subpoena use leading to admission of inflammatory, irrelevant evidence. That's already pretty bad. But then it gets even worse, right? The witness tampering allegations.
This is where, as the Chief Justice colorfully put it, on the second day of the trial, Thursday, April 28th, strange things began to happen. These were serious allegations about attempts to influence witnesses involving the plaintiff's solicitor, Arthur Kennedy, and his brother, C.S. Kennedy.
Okay, strange things. What exactly was alleged to have happened?
Two main incidents stand out. The first involved a witness named Violet Mary Bradshaw. She provided a sworn written statement, an affidavit, about what happened. She was apparently under subpoena, likely for the defense.
What did she claim in her affidavit?
She said Arthur Kennedy, Mrs. Small's solicitor, came to her house that evening, introduced himself, pressed her for a statement. When she refused, saying she'd already given one to the railway, he allegedly tried to get her to change her story.
How so?
She claimed he urged her to say Mr. Small was jolted out of the train. She insisted she hadn't seen a jolt, just saw him looking sick before he fell. She also alleged he appealed to her sympathy, saying Mrs. Small was a very poor woman, and even physically put his foot in her door to stop her closing it, only leaving when she threatened to call the police.
That sounds like serious misconduct for a lawyer. Did Kennedy respond?
Yes, in his own affidavit, he denied the key parts, denied trying to pressure her about a jolt, and denied the intimidating behavior like putting his foot in the door. So conflicting accounts there.
Okay. And the second incident involved the brother, C.S. Kennedy.
Right. This happened outside the courtroom, also on that Thursday. Another defense witness, a Mr. Smith, was sitting with a Constable Cunningham. Mr. Smith testified that C.S. Kennedy overheard him talking about the accident. C.S. Kennedy then apparently jumped in and told him, "You should not say fell, you should say thrown out. The judge won't stand for that. The train jolted and the man was thrown out."
Trying to feed him the jolt narrative again, and the constable heard this.
Yes, Constable Cunningham corroborated Mr. Smith's account of what C.S. Kennedy said.
So, pretty clear attempts, allegedly, to get defense witnesses to change their evidence to fit the plaintiff's theory, specifically mentioning a jolt. How did the trial judge handle these explosive allegations when they came up?
Well, this was another major problem identified on appeal. When Mrs. Bradshaw tried to mention the solicitor's visit during her testimony, the plaintiff's counsel objected, and the judge stopped her before she could explain fully. Apparently, the judge didn't realize the seriousness of what she was about to say. With the Mr. Smith incident involving C.S. Kennedy, the judge did confer with the lawyers in his chambers. He correctly decided the evidence was admissible, as it showed an attempt to tamper with a witness. But then, his instructions to the jury about how to view that evidence were found to be wrong.
What did he tell the jury?
He suggested they could see it in two ways. Either as an admission by the plaintiff that her case was weak, or maybe it was just some kind of joke.
A joke? That seems inadequate.
Chief Justice Jordan certainly thought so. On appeal, he said that direction was not correct. He explained that while a client isn't automatically responsible for unauthorized misconduct by their solicitor or agent, evidence of attempted subordination trying to improperly influence a witness was absolutely clearly admissible and most important for the jury to hear.
Why was it so important even if the client wasn't directly involved?
Because, Jordan C.J. argued, the jury needs to weigh all the evidence presented through that solicitor, knowing what methods their representatives might have used to gather or shape it. He also explicitly said it was most unfortunate that Mrs. Bradshaw wasn't recalled to give her full story about the solicitor's alleged visit. These tampering allegations were described as one of the most unsatisfactory features of the trial.
It really sounds like that first trial was just fundamentally flawed on multiple levels, far beyond a simple factual dispute.
That's certainly the picture painted by the Supreme Court's judgment. And Chief Justice Jordan added a significant note. Regarding the conduct of Arthur Kennedy and his brother, he stated they will be answerable in another place. That's usually code for potential professional disciplinary action or other proceedings.
Given all that, it's really no wonder the Commissioner for Railways appealed the verdict.
Not at all. They weren't going to accept that outcome. So they appealed to the Supreme Court of New South Wales, asking for a new trial. The appeal hearings happened in June and July 1938.
And we know the legal teams were heavyweights by this stage.
Absolutely. For the appellant, the commissioner, you had solicitor Fred W. Bretnall, with barristers Bradley Casey and Kinsella arguing the case.
And for the respondent, Mrs. Small, defending her win.
Her solicitor was still A.C. Kennedy, but her barristers were now Evad Casey and C.E. Martin, two very prominent King's Counsel. This was clearly a major legal showdown.
Before the bench of Jordan C.J., Davidson J., and Owen J.J. So what were the commissioner's main arguments on appeal? Why did they deserve a new trial?
They basically threw the book at the first trial. They argued the jury's verdict, especially on negligent driving, went against the evidence. They pointed to all the problems with how evidence was handled, stuff wrongly admitted, like the other accident files, and wrongly rejected, plus the witness interview issues.
And the prejudice.
That was huge. They hammered the point that the trial was gravely prejudicial because of how that subpoena was used right in front of the jury and the plaintiff counsel's inflammatory use of the other accident files. They also argued the damages were excessive and that the judge didn't properly instruct the jury, especially on contributory negligence.
A broad attack. How did Mrs. Small's team, led by Evat KC, push back?
They defended the verdict vigorously. They argued the damages were reasonable. On contributory negligence, they said the defense didn't object properly at the time, so tough luck now. They defended admitting the other accident evidence, citing legal precedents, they said, allowed it to show known dangers or feasible safety measures.
What about the prejudice claims? The subpoena, the files?
Their key argument there was waiver. They said the commissioner's lawyers knew about these irregularities during the trial, but didn't ask the judge to discharge the jury and start over. They effectively stood by, hoping for a win and shouldn't get a do-over just because they lost. They also argued the verdict could still stand just on the negligent driving claim, even if the safeguards issue was flawed and the damages were appropriate for that alone.
A real clash of legal arguments about procedure, evidence, and fairness. And the decision fell to Chief Justice Jordan.
Yes, and his judgment, delivered for the unanimous court, was incredibly detailed. A real meticulous and damning dissection, you might say. He found grave irregularities and serious prejudice had occurred.
Strong words.
Very. He said these flaws made the original verdict inherently unsatisfactory and concluded that ordering a new trial was imperative in the interests of justice.
Imperative. That really underlines how fundamentally flawed they thought the first trial was.
Absolutely. It wasn't just a minor error. Right. It went to the core of whether the defendant received a fair hearing. Jordan C.J. repeated his condemnation of the subpoena, its form, its timing, its oppressive nature, and especially how it was used in court to create that false impression of concealment. His analysis basically became a textbook example of how not to use subpoenas.
And the improper evidence, like the Skinner file.
He was equally clear on that. Admitting those other accident files, especially the one mentioning the £1,000 payment, was matter more improper or more likely to cause serious prejudice. Full stop.
What about the witness tampering allegations? How did he view the trial judge's handling of those?
He found the trial judge's direction to the jury on the C.S. Kennedy incident was not correct. While a client isn't automatically liable for unauthorized misconduct by their lawyer, he stressed that evidence suggesting attempted subornation was clearly admissible and most important. The jury needed that context to weigh the evidence presented by that side, and he reiterated it was most unfortunate Mrs. Bradshaw's full account wasn't heard.
So the procedure, the evidence, the handling of tampering claims, all severely criticized. What about the actual negligence claims? Did the appeal court think the jury got those wrong too?
He addressed both grounds separately. On negligent driving, he conceded the jury's finding was somewhat surprising, maybe not what he would have found. But crucially, he felt the evidence wasn't so overwhelmingly against it that you could say no reasonable jury could possibly have found negligence. So that issue could be retried.
But the other claim, failure to provide safeguards.
On that one, he was decisive. He found there was simply no evidence presented at trial to support it. Just because an accident happened or because different doors existed elsewhere doesn't prove the railway was negligent. There was no proof the existing design was unsafe or against standard practice. He felt the trial judge wrongly left it to the jury, basically asking them for their opinion without any solid evidence of a breach of duty. So his ruling That issue should not go to a new trial.
Okay, so the Supreme Court made its decision. What were the final orders? What actually happened as a result of the appeal?
Right. The final orders were, 1, the appeal was allowed. 2, the original verdict for Mrs. Small and the $724 damages award were set aside, gone.
Okay.
3, a new trial was ordered. But this is critical. It was limited only to the first issue, the alleged negligence in driving and controlling the train. The safeguards claim was completely out.
And the costs. Who paid for the appeal?
The appeal was allowed with costs. That typically means the loser on appeal, in this case, Mrs. Small, would be ordered to pay the legal costs incurred by the winner, the commissioner for the appeal itself.
Wow. So for Mrs. Small, that's just devastating. Her win is gone. She faces another trial. Her case is narrowed down. And now she probably owes the railway money for their appeal lawyers.
It's a very harsh outcome from her perspective. The court clearly felt the first trial was fundamentally unfair to the railway, but the consequence of fixing that unfairness fell heavily back onto the widow and her family.
This case definitely resonates beyond just its specific facts, doesn't it? What's its lasting significance?
Oh, hugely. It's a major cautionary tale in legal ethics and procedure. Jordan C.J.'s rulings on subpoena abuse, improper evidence, and the admissibility of witness tampering evidence became important precedents. His judgment serves as a clear warning about the duties lawyers owe to the court, not just their clients.
And it really highlights the human cost.
Absolutely. You see the immense emotional and financial strain on Mrs. Small and her children, a flawed trial, a verdict overturned, the prospect of more litigation, the costs. It's a stark reminder of the toll legal battles can take.
But it also shows the legal system trying to correct itself, perhaps.
Yes, I think that's fair. The appeal court's detailed review and its readiness to overturn a verdict based on procedural unfairness shows the importance of that appellate function. It's about ensuring fair trials, even if the path to correction is difficult for those involved.
Though, as you noted, the source material leaves some big questions hanging.
It really does. We know a new limited trial was ordered. But did it actually happen? If so, what was the final result for Mrs. Small? Did she eventually receive any compensation? We don't know from this judgment. And what about Arthur Kennedy and his brother? Were they ever held answerable in another place, as the Chief Justice suggested? The record here is silent.
So we've traced this journey from a shocking personal tragedy on a train through a first trial filled with grave irregularities and serious allegations against the legal teams involved, right up to this landmark appeal judgment that dissected those flaws and ordered a very specific limited do-over.
And Commissioner for Railways v. Small really drives home that justice isn't just about what happened in the accident. It's fundamentally about how the case is conducted, the integrity of the process, the ethics of the solicitors and barristers, the decisions of the judges. These historical cases, they reveal timeless truths about how challenging it can be to achieve real justice through the legal system.
The Chief Justice said a new trial was imperative in the interests of justice because the first one was so broken. But you have to ask, after everything, the death, the flawed trial, the appeal win being taken away, the narrowed case, the crushing costs, could Mrs. Small and her family ever have truly felt justice was served in the end? That's the question this case leaves echoing, unanswered in the records.